Good morning, and thank you for joining me on the path to liberty. It's Monday, February 8th, 2021. I've got a ton of information on this episode, but I'm going to start out with James Madison briefly, end up with Thomas Jefferson, but a ton of interesting stuff in between. We've got basically, for fun, a head-to-head battle between California and Missouri. Not really those specific states alone. There are others, but I think they are really the standard bearers for state-level resistance to federal acts on two very opposite ends of the spectrum. On the one side, we now have over 25 years of experience. And on the other, I hope while they are ramping up their efforts and learning more and more about this process to reject, resist, and nullify federal acts, that they can look to their opponents and actually learn from them. There's quite a bit to learn. So as we go through this and I give a brief overview of what's going on, I've got 5 huge myths that are really actually very persistent among a lot of the new people. And I think understanding them is essential to the future of nullification strategy for liberty. First of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage has everything you need to follow this program. It's 10thamendmentcenter.com/path to liberty, all spelled out. You've got all the archives for the show for over 2.5 years. Individual episodes like this one and every single one, I will include a bunch of links to stuff that I talk about in the episode so you can read and learn more on your own time. Every single time, no matter how much I'm long-winded, it really is just scratching the surface, and there is a ton of info out there for you to take up and learn more. We also have all the different platforms we're on. So, for example, if you watch us live stream on YouTube or Twitter or Facebook, and you're wondering, why are they gone from that platform today out of nowhere? Maybe we'll be somewhere else, like on DLive or on Brighteon or BitChute or Library.tv, or Odyssey, or Gab TV now as well. We upload the archives there amongst a bunch of other platforms. Sometimes we're on MeWe as well, but there are file size limitations. We also have the podcast edition over on Apple Podcasts, Podbean, Spotify, iHeartRadio, TuneIn, etc. You can also find our membership program where you can put your financial faith behind our work. All that and more, of course. 10thamendmentcenter.com/path to liberty, all spelled out. 10thamendmentcenter.com/path to liberty. And I couldn't be more grateful for you spending some of your time with me today. Thank you for being here, whether it's your first episode or you've been here for every single one since day one. But while we allow people another minute or so to get notifications to join us for this live stream, live broadcast, I want to say hello to as many people as possible that I can see is scrolling through out in the chat. There's Liberty Revolutionary, Tim Martin in Arizona, Dixie Strong in Bama, Patricia Dance in Syracuse, New York, Clay Kent, good to see you. Jacqueline Lopez in Granbury, Texas. MRGF, Israel. Dan Reed, Jay Armstrong, Marcus, Larry Clark, Clay Davis, Tyler B., Irwin, DHD, another Lawrence, I think, Isaias. Oh, Liberty Revolutionaries in Missouri. That's pretty cool. I think I'm getting it right. I was talking to my friend Ron Calzone, who's leading a lot of the efforts in Missouri, and I'm on a conversation with him, and I keep saying Missouri, and he's so nice. What a hardworking activist. If you really want to learn how activism on the right or on the liberty end of the spectrum is done, I think Ron Calzone does really great work at a state level, and so does Gary Marbit up in Montana. Anyways, let's get right to this. I want to start out with James Madison. Like I said, we follow a strategy of James Madison that he advised in Federalist 46, 4 steps to stop and defeat federal programs, and in Madison's words, whether they are warrantable or unwarrantable. Doesn't matter, and these are the terms that he used for authorized by the Constitution, warranted by the Constitution, or not. 4 steps. Not one of them included the things that most people do today, and those are all focused on taking over the people in Washington, D.C., or begging them to do things that we want them to do. Madison advised things for individual and states, and most prominent among those, I think, is his advice to use a refusal to cooperate with officers of the Union. His advice, not mine, I'm just repeating them. And I'm not going to get into too many details because I just did an episode in a lot of detail on that just late December, just before Christmas. James Madison How to Defeat Federal Programs. It's not only covering his advice in Federalist 46, but how he started the process of implementing that advice in response to the hated Alien and Sedition Acts of 1798. The Virginia passed resolutions drafted by him on Christmas Eve, December 24th, 1798. I encourage you to check out that episode so you can learn more detail about that strategy. I do also want to make note, and I've done this many times here, that this isn't just some arcane legal philosophy or constitutional philosophy from some dead founder that we can ignore. I mean, we never should anyways, but that's the way a lot of people treat things, unless they've been sanctioned by the political class of today. And we are lucky. We don't rely on this. We don't beg for it. We don't need it, but it makes it less difficult to get the job done when you get the support of the Supreme Court. Now, the court has actually reaffirmed Madison's advice in Federalist 46, a refusal to cooperate with officers of the Union on a state or a local level, in a series of 5 major cases from 1842. That was a Prigg versus Pennsylvania. This is a Fugitive Slave Act case. And then all the way most recently, there's a sports betting case in 2018. It's called the Anti-Commandeering Doctrine. And the short version, it's just summing up what Madison advised. The federal government cannot require states or localities to use resources of any type, personnel, money, anything, logistics, to help implement, effectuate, or enforce federal acts or regulatory programs. Now, if the Supreme Court eventually gets this wrong, and I know there are people who want to get rid of this on all sides of the political spectrum. They don't like it when there isn't a uniform policy that has their personal views for everybody and anybody. And that's really a huge problem. We don't want that. We want people to be able to have their own views in their own area. That's why the founders set up a federal system rather than one centralized blob. But if it's ever gone, we're still going to follow James Madison's advice. No matter, even if the Supreme Court decides to stop agreeing with him over time, we still have his advice. There's others, James Otis, Roger Sherman, Thomas Jefferson, and others, and we are going to keep pushing forward. So let's get right to Missouri. And I apologize to anyone who lives there if that is incorrect, but that's how I'm going to try to push forward with the name of the state. My lovely better half grew up in West County, St. Louis, so I get there every few years or so, and I should actually get this right by now. But you've heard me talk about on this show the Missouri Second Amendment Preservation Act, House Bill 85 from Representative Jared Taylor. It's been combined with another bill, almost the same, House Bill 310, Bishop Davidson, a rookie. This guy's only in his 20s, pushing to nullify all federal gun control, past, present, and future. Here, just a quick overview. Titled the Second Amendment Preservation Act, the legislation, which actually passed the House 103 to 43 last week, it's got to go through the Senate, and it could sail to the governor if there's a lot of support in the grassroots. The legislation would ban any entity or person, including any public officer or employee of the state and its political subdivisions, from enforcing any past, present, or future federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, statutes, or ordinances that infringe on the right to keep and bear arms. You can see pretty clearly here, if we're following James Madison's advice, it says, use a refusal to cooperate with officers of the Union, and then part of that 4-step process was to use state-level legislative devices, this were Madison's terms, legislative devices, to basically implement that. And then you have the Supreme Court, surprisingly. I mean, the Supreme Court generally sucks, really, really bad, but when they get it right, it sure makes it easier, less difficult, like I was saying, with state legislators, because they basically take the position of, well, we can't do this. We don't want to, turn over too many apple carts. And unless we get permission, we really need to just follow the rules that we're allowed to do. And that's just an unfortunate part of their bootlicking. But, and I don't know if Jared Taylor's one of those guys. I'm assuming not from what I've seen this guy do. But when you have someone who's willing to take a stand on this, and then all the establishment is like, but the Supreme Court says you can't do that, you're almost dead in the water. So when the Supreme Court actually affirms the strategy, it actually makes that strategy far more palatable. They don't have that argument to say, well, you can't do this. Because we're like, well, Samuel Alito has said this, Justice Scalia said this, etc. So Taylor, his bill is using this strategy, or trying to use this strategy, to undermine federal gun control, none of which should exist in the first place, but to undermine, defeat, reject, resist, nullify Whatever you want to call it, it doesn't matter. You can call it the Easter Bunny if you don't like the word nullify. I don't care. The end result is we don't want any of that gun control enforced ever again. And this is a huge step forward. But, there are a number of other states that have been doing this or looking at doing this, kind of following Missouri's lead. There's a very similar bill in Wyoming and Nebraska. There are other bills that try to take the same approach, but sometimes they seem to either be very confused about what they're trying to do. Maybe they're grandstanding, but we see some good legislation, at least from my view, in Alabama. There's some so-so in Arizona, and I'm going to cover one in South Dakota. But basically, there are about 9 states so far, maybe 10, that are trying to take this type of approach in 2021 against federal gun control. We hope that that expands and that they actually learn really good strategy. But they're way behind schedule, really by a couple of decades. Because even if Missouri was the first to go this broad against federal gun control in 2021, there have been efforts on the books from the other end of the political spectrum, which a lot of people on the Missouri side don't like. But they've been around for 20 to 25 years. Let's go to Oregon. Originally passed in 1987, House Bill 2314 reads in part, no law, and you'll recognize the approach here because it's very similar to House Bill 85 in Missouri. No law enforcement agency of the state of Oregon or of any political subdivision of the state shall use agency monies, equipment, or personnel for the purpose of detecting or apprehending persons whose only violation of law is that they are persons of foreign citizenship present in the United States in violation of federal immigration laws. So 24 years ago, Oregon was the first state in the country that I'm aware of to really use in modern times this, we are not going to enforce federal programs, a particular one in our state. They're using anti-commandeering really before any of the modern cases. The original case was in 1842 where the Supreme Court backed up James Madison's strategy, but all the other cases have been 1992, 1997, 2012 and 2018. So before they had all the additional modern Supreme Court jurisprudence, they just went ahead and did this. It passed the House 54-3 and 29-1 in the State House. There have been some modifications to it over the years and some efforts to repeal it. It's never been challenged in court because, well, any challenge would clearly lose because they're actually strongly supported by this whole notion that you can't, even if you don't like them doing this, the fact of the matter is they aren't required to help the federal government do stuff that the federal government shouldn't be wasting time doing other things that are unconstitutional. Maybe they should do their own job in the first place instead of trying to corral everybody else into it. Anyways, that's a different discussion. They aren't alone, of course. There's also San Francisco. And I know a lot of people on the right are going to say, oh, grown San Francisco. And they don't even like paying attention to them. They don't want to see what they've done. They just hate them. They think they're a bunch of commies rather than learning. So if the commies are taking over everything, wouldn't you want to learn how they pull it off? Well, if you don't, that's your own problem. Anyways, in San Francisco, 2 years after Oregon did this, in 1989, they passed what is the very famous San Francisco Immigration Sanctuary Ordinance. It's called the City and County of Refuge Ordinance, also known as the Sanctuary Ordinance. This is from the San Francisco local government website. It generally prohibits city employees from using city funds or resources to assist Immigrations and Customs Enforcement, ICE, in the enforcement of federal immigration law unless such assistance is required by federal or state law. In 2013, they did a modification of it. They passed a due process for all ordinance. This ordinance limits when city law enforcement officers may give ICE advance notice of a person's release from a local jail. It also prohibits cooperation with ICE detainer requests, sometimes referred to as ICE holds. So Oregon in 87, San Francisco in 89. We can jump forward and skip a little bit, but in 2013, California followed up on this statewide with a very limited thing called the Trust Act, 2013. You can't call this just partisan stuff because you can think of who may have been in Washington, D.C. at that time. But in 2013, they passed the Trust Act. And if this is from the digest from the Legislative Council, from the bill from Amiano, it prohibits a law enforcement official from detaining an individual on the basis of an ICE hold after that individual becomes eligible release from custody, unless at the time the individual becomes eligible for release from custody, certain conditions are met, including, among other things, that the individual has been convicted of specified crimes. Blah, 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 blah. Basically, a lot of times, these dinosaur agencies, they're just slow. I mean, they're not very reliable. I could barely get the mail in time. You send something. We've had people send things to us at our P.O. Box 90013, P.O. Box 13458, Los Angeles 90013. In case you want to send a check our way, I should throw that out there. But people do that, and I'm very grateful for it. But I've seen on the postmark, sometimes it's like 3 weeks earlier, and it takes 2-3 weeks for them to show up with the mail just from halfway across the country. It's nuts. Government is not reliable in what it does. Government is not good at what it does. In general, it steals stuff, it promises things, it never does what it promises, or it costs way more, so it's lying in the first place. But ICE will oftentimes send these things known as detainer requests to local law enforcement, local jails, things like that. And it's right, if they're waiting till the last second. They're like, oh, hey, we want to come and pick this person up. You got to hold them for longer than their release date. And this law in California basically is saying, no, we're not going to do that. We don't care. I mean, they're really not on board with ICE, clearly. And they found a legal loophole that allows them to help undermine this. And that was in 2013. There's about 35 different exceptions of things where someone may have been convicted of that they're saying, well, if you've done these types of things, we don't care. We're still going to hand you off to ICE. And so, but there's a lot of, anyways, without getting into too many details. Then we move forward to 2017 in California. That's the California Values Act of SB 54. It ensures that no state and local resources are used to assist federal immigration enforcement. So in 2013, they started out with a kind of a narrow thing. We're not going to help enforce in this. And a lot of people are pissed off about that. And then they said, well, on both sides of that spectrum, the people who want them to help the feds and the people who don't, it's never enough, right? So what they did was they pushed forward. It took them 4 years almost to get the follow-up bill. It's a 2-year session every 2 years in California. But they followed up with this California Values Act, this sanctuary state law in California. It ensures that no state and local resources are used to assist federal immigration enforcement. And it was signed on October 5th by Jerry Brown, went into effect January 1st, 2018. So cops can't ask about immigration status in California. They can't arrest you for having a deportation order. They can't use ICE people as interpreters. I mean, there's a bunch of exceptions to this, and I'll actually pull up that bill in a little bit, but I want to actually explain why people don't like this. People who don't like these immigration sanctuary cities, 300 some odd of them, the states are talking about Oregon, California, and elsewhere. The reason they don't complain about it is not because it hurts their feelings to say, oh, cops can't ask illegal immigrants about their immigration status. It doesn't hurt their feelings to be like, oh, look what they're saying. They don't want to help ICE. They think ICE is a rogue agency, and that makes me angry and feel bad. That's not why. Well, maybe some people are that snowflakey wimp that that's all that it takes to get them upset. But the real reason that people are pissed off about these types of things is because they have a significant impact on the federal government's ability to enforce federal immigration law. And we know this because ICE tells us this. Year in and year out, I read the annual ICE reports. There's the general overview of what they do, and then they also do something called the ERO report. This is Enforcement and Removal Operations. ERO report. You can get it from their website. I encourage you to go through there and read because, of course, whatever side of this you happen to be on, you want to understand what they're doing, what roadblocks they have, and why. Well, ICE tells us what's going on. Here from the 2020 report, they say in fiscal year 2020, ICE ERO, Enforcement Removal Operations, issued 122,000 some odd detainers. This was a 26% decline from February 2019. Here's the gem from ICE. This was likely impacted by decreased numbers of individuals in state and local custody nationwide. The number one thing that they mention is that state and locals are not holding people in custody. Number one. They also had a temporary reduction in enforcement activity like a lot of government agencies did in 2020, but they also reiterate this. An increasing number of jurisdictions that do not cooperate with immigration enforcement activities and court rulings limiting ICE's ability to lodge detainers. Here's in 2019, their 2019 report. They say this is again from ICE's own hands, they say one of the biggest impediments to enforcement and removal operations efforts during fiscal year 2019 was the lack of cooperation from an increasing number of jurisdictions nationwide. So we know that ICE is telling us, and this, we can say, well, maybe they're just saying this. Maybe they're just being political and telling us, well, they want to get more. But why would they spend the time putting in their report year after year? And you can go back over the years, and they increasingly have been ramping up how much they're pointing out how a refusal to cooperate on a state and local level is impacting what they're doing. Now, you can love that. You can hate that. That's not what we're getting into. If you want to have that kind of debate, go elsewhere. What we want to do is learn how this stuff plays out. We know that there was recently a study done by, I don't know, somebody at Stanford, some pretty prominent dude at Stanford did a study of how these sanctuary policies have impacted. So it's not just ICE's word. There's a study from probably the other side of the spectrum there as well. They studied 2000 to 2015, how this impacted. And they said overall, deportations reduced by about 1/3, 33% reduction in places with sanctuary policies. And immigrants arrested but not convicted of a crime were about 50% less likely to get deported. So we know this is having a huge impact, and they're really having tons of exceptions. So in the California Trust Act, there were like 35 exceptions to say, well, in all these situations, we've carved out areas where we're still going to help federal immigration enforcement with these detainers. And there's even more. I don't even know the total number, but there's dozens of them. And I know because I've been on phone calls where I've heard people complaining about that, people who want it to be much stronger on the sanctuary end of the thing against federal immigration. They want no carve-outs. And we always hear that no matter what the issue is. They don't want any exceptions. But even with all those exceptions, it's still having a heavy, heavy impact on federal enforcement capability. So let's compare that with some of the things that are happening in regards to legislation to take on federal gun control in the states. And I want to start out with some of the things that people think you have to have. First of all, some people believe that you have to have penalties for federal agents who violate the state law. For example, this bill, Senate Bill 2564, which actually has some very good anti-commandeering requirements to stop enforcement, also includes this language. Any official, agent, or employee of the United States government who enforces or attempts to enforce any of the infringements on the right to keep and bear arms included in subsection 2, they list a bunch of stuff, of this section is guilty of a misdemeanor. So they're saying in this piece of legislation that you have to, if a federal agent tries to violate someone's right to keep and bear arms, and I get this concept, I get it, they are violating someone's rights. If anybody should be in jail, those people should be, not the person with the gun, as long as it's not for what you own or what you buy or sell, only if you've committed a crime. So taking someone's right to keep and bear arms away from them is a crime in my book, and I understand the theory behind this. But in practice, anytime you try to charge a federal agent, what happens is that that case, even if you charge them, they're going to take it to court. Let's say somehow you get it into state court. As soon as it goes into state court, they're going to make a motion to remove the case to federal court, and every single judge in the country, there is not one judge that I have seen, and maybe someone can prove me wrong, but there's not a single judge in the country who will refuse to comply with that. And if they do, the feds will come in and just take the case anyways. So once it gets to federal court, the feds say, well, you can't do this, and then you've lost. There's no way to pull this off. And we know that there's this type of thing in these very, very effective, the things that piss people off the most on immigration sanctuary cities. Oregon doesn't have this. California, San Francisco, no immigration sanctuary jurisdiction has something that calls on the local or state jurisdiction to arrest federal agents. And in fact, James Madison himself didn't include that in his strategy in Federalist 46. He said specifically a refusal to comply or refusal to cooperate. He didn't say go have a standoff like OK Corral style, even though that wasn't around yet. But don't have a standoff with the feds. Just don't help them. And he said if a number of states do this in unison, it would create an environment which the federal government would hardly be willing to encounter. That's Madison's words, not mine. And I think the father of the Constitution knows more about how this stuff works than I ever could. So number one myth, it is a myth that you absolutely have to have. It's a myth that it's actually a good idea to include this type of language in legislation to take on federal acts, to nullify. It's a myth. And in fact, most of the time when you do this, when I've seen bills do this over the last 10 years, they all die. If they even get to a committee hearing, they're almost always voted down, or the one or two times where they have passed over the years, no one's ever followed through. They just don't do it because they're afraid of what will happen. Now, this particular bill, Senate Bill 2564, we don't know exactly how it played out. Mississippi is notoriously the least transparent state legislature in the country. It's definitely a good old boys situation there. And that bill was killed in committee, voted down, rejected, and so it's dead. I also want to look at, so that's myth number one, that you have to arrest the feds. This is bad strategy. Don't try to do it. The people who are being real effective against federal acts aren't trying to do it, and we can learn from them as well. So number two, a lot of people think that you have to discuss constitutionality in the legislation. Here is a bill that I think has potential in Arizona, but as it goes through the process, there's a hearing for it this Thursday. I hope that they can make some changes to it. Let me just read a few sections. Senate Bill 1328, I believe. Let me take a look here. Senate Bill 1328 in Arizona. And it says, pursuant to the sovereign authority of this state and Article 2, Section 3 of the Constitution of Arizona, which discusses that the state actually doesn't have to participate in the enforcement of federal acts. It's basically following up on James Madison and the anti-commandeering doctrine. So pursuant to that, now, I like how they actually don't even mention Madison, and they're not even mentioning the anti-commandeering doctrine in the enacted section of this legislation. They're just saying this is a state constitutional issue. We don't have to participate, and that's pretty cool. They say specifically, any act, law, treaty, order, rule, or regulation of the United States government that violates Article 2, Section 26, Constitution of Arizona, or Amendment 2 of the Constitution of the United States is null, void, and unenforceable in this state. Sounds good on its surface if you're not really sure what they're doing here. But they say this state and political subdivisions of this state are prohibited from using any personnel or resources to enforce, administer, or cooperate with any act, law, treaty, order, rule, or regulation of the United States government that violates the state constitution or that violates the Second Amendment to the Constitution for the United States. Now, basically, they're just saying if it's unconstitutional, it's unconstitutional. And if it's unconstitutional, we won't enforce it. It's a kind of a circular argument. Now, if you compare that with the Oregon legislation passed in 1987, they don't say anything about it has to violate the state constitution. They just specifically say this again. No law enforcement agency of the state of Oregon or any political subdivision shall use any state agency monies, equipment, or personnel for the purpose of detecting or apprehending people who violated civil immigration law. They didn't say if that arrest or those resources violate the state of Oregon's constitution or any other part of the federal constitution. They don't give that if statement. And as soon as you add that if statement, you're basically giving them political cover. It's an out. And virtually every law enforcement agent in the country, when they're presented with you're not allowed to arrest people for things, for laws that are unconstitutional, they already believe that that's what they're doing. They just believe that it's not their job to make the decision. So as soon as you add an if this violates the Constitution, you're inserting, rather than a directive, hey, just stop enforcing these things, you're inserting a question into it. And in almost every scenario that I've ever seen on this, as soon as you issue a question in there, no one changes their enforcement because they're like, well, that's the court's job. You're basically kicking the can. You're creating this loop where nothing actually changes in practice. So the second myth that hopefully that makes sense to you guys, because if you compare the Oregon law versus the effort in Arizona, one just says stop enforcing. The other one says stop enforcing if it violates the Constitution. And that means no one really will stop enforcing anything until they're told that what they're doing is unconstitutional. So it creates this endless cycle of nothingness. And that's myth number two, that something first needs to be deemed unconstitutional before you refuse to participate in the enforcement of it. In fact, as I mentioned already, James Madison said this specifically in Federalist 46, whether something is warranted by the Constitution or unwarranted. If the states do not like the policy, they just refuse to cooperate, they opt out. And this, again, was reaffirmed by the Supreme Court as recently as 2018 in Murphy versus NCAA. Here, the court held that Congress can't take any action that dictates what a state legislature may and may not do, even when the state action conflicts with federal law. Samuel Alito put it this way: a more direct affront to state sovereignty is not easy to imagine. Myth number 2, you have to include a statement of constitutionality. In fact, when you include that in your nullification legislation, you can be sure that you have to do a follow-up to say, well, now we're taking the position that these things are determined to be unconstitutional. We saw that with legislation, an attempt to protect the right to keep and bear arms from federal interference in Tennessee a few years ago. And once they did it, of course, that was their ability to grandstand and say that they were doing something. And then there's been no change in Tennessee. So you have to actually just tell them, stop enforcing. Don't give them an out. Don't give them an opportunity to kick the can to someone else, and just tell them to stop. Now, the third thing I want to talk about is including penalties for violating. Not penalties for federal agents, because that's just bad strategy. Even if you think it's something that has to happen, it just doesn't work in the status quo. Maybe in the future that'll change. We can get to that in a few years once we ramp all this other stuff up. Here from the Missouri bill as passed, they actually originally included penalties for state law enforcement agents. They also had an ineligibility clause. If someone was deemed to have knowingly worked as a federal agent in doing this, they would forever be ineligible to serve in law enforcement in the state. And they actually changed that. Well, this is what I think was kind of cool too. It says sovereign, official, or qualified immunity shall not be an affirmative defense in such actions. So now they actually changed that instead of to the individuals, because there was such great opposition from law enforcement lobby groups and some people who are claiming to be supporting this. Some, like 36 or so state legislators, were willing to walk out and basically try to kill the bill or not give it enough votes and give them an excuse, because they were like, we don't want to punish cops. They can't ever be bad. And this is really just, government by cop is not really a good choice. Anyway, so they changed it to actually put the penalties on a political subdivision or a law enforcement agency. If they're hiring people, they can get sanctioned. They can lose some funding. They can actually get lawsuits. For example, they can have a $50,000 fine of a civil penalty if they start hiring federal agents who are violating the state law, should it pass. Now, in San Francisco, let's look at this again. In Missouri, they're trying, and I think there is something to be said for this. This is not necessarily bad strategy, but let me make the comparison. In Missouri, they're trying, and in Wyoming, they actually have penalties at SF 81 on individual agents, and they may end up changing that as they go through the process too, like Missouri has, but we'll see. In San Francisco, this is the enforcement section. What happens if local law enforcement does not follow this local ordinance? They say this. This is so very Bay Area. The Human Rights Commission shall review the compliance of the city and county departments, agencies, commissions, and employees with the mandates of this ordinance in particular instances in which there is question of noncompliance or when a complaint alleging noncompliance has been lodged. In other words, no penalties at all. There is no penalty. They're basically saying, well, maybe someone will file a complaint. We're just stop enforcing this specifically. And if there's complaints, then there's a commission who are going to review it. And they don't say any specific actions that are going to happen. That is in San Francisco. In Oregon, here's the bill. I will include a link to this in the show notes. Here's the law. It's 181A.820. It is on the books in Oregon laws, and you can read through it. There is zero mention about enforcement for violation of the act. Same with Senate Bill 54, the California Values Act. You can see as I'm scrolling through here, there's dozens and dozens of exceptions for where they will still help with federal immigration enforcement, including things like vandalism with prior convictions, gang offenses, conspiracy, possession of an unlawful deadly weapon, because they hate the right to keep and bear arms in California more than most any other state. so they're happy to help out with federal gun control. But none of these have even sanctions at all in the act on even state or local agents. So the third myth is that you have to have penalties, or what a lot of people ask for is teeth on state agents to make it effective. Now, it could be more effective. We don't know, because none of these have really just gone forward or been enforced like that yet. But we do know that even without the so-called teeth on both federal or state agents, everyone who doesn't like immigration sanctuary cities seem to have a problem with them, because they're obviously incredibly effective, and ICE has told us so. And then the next thing I want to talk about is law enforcement. The heaviest opposition to our efforts in places like Missouri is from law enforcement lobby groups. We had this a lot in Arizona and Florida and elsewhere. But they tell us, like, for example, like a sheriff's association, we hear this very often. They say if they can't participate with federal enforcement on gun control, we're taking away the tools that they need to enforce federal drug laws or state drug laws. They look at it as a force multiplier. Basically, if they catch somebody with a bunch of weed, and they have a gun, because most people will have a gun in that scenario, especially if you had stuff that you're involved in dangerous business, black or gray market business, you of course are going to be more willing to exercise your right to keep and bear arms than your average, dorky white suburbanite who never has to go anywhere other than the shopping mall. So not that those people don't want to defend themselves either, but I think in that situation you find a lot of people, and if you read through the arrests, public notifications and press releases about prosecutions, almost every time that they're talking about a drug offense, they also get a force multiplier. Oh, they had an illegal firearm, they had illegal handguns, or an assault weapon, which is a terrible word, that it's a term of propaganda. But basically they say, look, turn over who are you working with? You've got a gun here. This is going to be an additional penalty. And there's penalty enhancements for having an illegal gun or a gun involved in a drug crime. You're going to get an extra 10 years unless you give us a name. So they use this to arrest people. And I'm sure they're actually telling the truth when they actually tell us that they're using it like this, that they are able to get more convictions. But at what point is enough going to be enough when it comes to drug war convictions? Here, Normal just tweeted just a few days ago, 545,602 Americans, 500,000 plus people, were put in steel handcuffs in 2019 alone just for marijuana offenses. They said that's more than one person every minute. And by the time you read this Twitter thread, another person will have been arrested. So let's say it's not enough. Does the Second Amendment actually need to be destroyed to save us from pot? I mean, at some point, this is beyond absurdity. We should not give them an inch on this. And first of all, the war on drugs is as unconstitutional as can be, but I'm not really getting into that. But let's just give them all that. At what point do you say we want them enforcing federal gun control just so they can throw even more people in jail over a plant that is naturally occurring? So myth number 4 is you don't actually have to get law enforcement on board. They are going to oppose. First of all, myth number 4 is a doubler. That law enforcement is on board. In general, the greatest opposition to this comes from law enforcement lobby groups. That doesn't mean the rank and file thinks the same, and sometimes there's some conflict. But the ones with the power and state legislators, they roll in, and people don't. A lot of legislators, if they hear a law enforcement lobby group say this is not good, it's taking away our tools to get bad guys, then they're going to just wither away and vote no. But you don't necessarily need support. And in fact, in California, SB 54, that California Values Act, California is very much governed by cop. But the state legislature had huge opposition from law enforcement groups. And when I watched that actually play out, some hearings and things on it, you'd have representative after representative just lined up in law enforcement uniforms to testify against the bill. And here's a statement. It's just a screenshot from a tweet. Basically, it says the California State Sheriff's Association, even after they included a bunch of carve-outs to it, they said they remain opposed to this measure unless it's further amended. And at that point, it was either the governor would have to veto it and do it another time. In other words, no matter what you do, if you try to restrict their abilities, you're going to get opposition. So myth number 4 is you really don't have to get law enforcement support to get things moving. At some point, you have to reject some of these bad arguments and just say, you know what? 545,000 people arrested. A 3-year sentence is good enough rather than a 5-year sentence. 546,000 people. We don't need to do more. We don't have to sacrifice our right to keep and bear arms so you can arrest even more people. And then one other thing that I want to talk about is courts, and that'll lead me to the last strategy. I apologize for going long. I told you there's going to be a lot of info. A lot of people think that the entire strategy is about getting a favorable court ruling. Here, for example, South Dakota Senate Bill 129, which is up for consideration in committee this week. They actually include a list of all kinds of federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations that are deemed to be unconstitutional by the legislature. And it's very similar to the bill in Missouri, in Nebraska, in Wyoming, and elsewhere, and they include all kinds of stuff. But then you get to the kicker. At the end, it says, the Attorney General, this is what they say they're going to do. The Attorney General shall, so it requires the Attorney General to take action, on behalf of the residents of this state, object to and litigate against any action that violates this section. So they're saying there's all these things, firearm tracking, registration, tax, levies, fees on firearms, ammo, accessories, etc., confiscation. So they're saying litigate against this. Okay. And then it says, during the pendency of any litigation in accordance with this section, no state agency, political subdivision, or any elected official or employee of this state may attempt to enforce any federal act that violates what we're saying in this list. So in other words, they're saying, you know, we think all these things are unconstitutional, and we're telling the Attorney General to look at this stuff and start a lawsuit. And during the lawsuit, we're not going to comply. So basically what they're telling us is, as long as the Supreme Court gives us permission to, and they rule in our favor, then everything's cool. But that's just the status quo, because if the Supreme Court strikes down the National Firearms Act of 1934, everyone's going to stop enforcing it anyways, except those places that have something similar on a state law. But that law will be gone. So basically what they're telling us is, we just want a bunch of lawsuits. We will only refuse to participate in federal enforcement as long as the federal courts give us permission to. This is not a resistance. This is not nullification. It's actually one of the weakest approaches I have actually ever seen, and a very similar piece of legislation to deal with federal executive orders. They took the exact same position. They took a stronger bill in North Dakota, amended it to basically this. We will do this as long as the federal government tells us we can, even though we've had the Supreme Court telling us for 150 plus years that you can opt out of any federal program. You don't have to spend resources to actually participate in the enforcement. This has already been litigated. So if you want a court case, they've already happened: 1842, 1992, 1997, 2012, and 2018. I include all of those in this article, Anti-Commandeering, an overview of 5 major Supreme Court cases, which you can read at your own time to get some coverage of it. Now, let's also mention cannabis. In 2005, back in the day, I used to think that if the Supreme Court took a position that said a state law didn't matter, that the feds were supreme in a conflict, that if anybody had that law in the books, they would immediately repeal that. Well, that's what we had happen. Well, not totally happened, but in 2005, the Gonzalez versus Raich case, this was a cannabis case between Angel Raich and people in California, Prop 215, where they legalized cannabis for limited medical purposes, well, somewhat limited at the time. And the feds were saying, this is, you can't do this, supremacy clause. A couple of presidents came to the state to lobby against it before the vote. The people voted anyways. And so there's this lawsuit. And Angel Raich went to the Supreme Court, and she lost in Gonzalez versus Raich. And at the time that case happened, that case came down, there were 10 states with medical marijuana laws on the books. And since then, not one of them has repealed. And now today, despite federal prohibition, Mike Meharry writes, 36 states have legalized marijuana in some form. And during 2020 in November, 4 more states legalized, bringing the total legalized recreational for the general public, not just medical, bringing that total number to 15. So myth number 5 is that we need the Supreme Court. In fact, successful efforts aren't based on getting a court ruling in our favor. And that's how I've put it a number of times from this great article from Derek Sheriff that I want to cite one more time before we head out here. He puts it this way to describe nullification. I hope you take this with you and hold it close. Nullification is not secession or insurrection, but neither is it unconditional or unlimited submission. Nullification is not something that requires any decision, statement, or action from any branch of the federal government. Nullification is not the result of obtaining a favorable court ruling. Nullification is not the petitioning of the federal government to start or stop doing anything. Nullification doesn't depend on any federal law being repealed, and it does not require permission from any person or institution out of one's own state. And as I promised right off the bat, I would close out with Thomas Jefferson, and this is a great passage from a letter that he wrote to his friend, the Reverend Charles Clay, in 1790. He put it this way: "The ground of liberty is to be gained by inches, that we must be contented to secure what we can get from time to time, and eternally press forward for what is yet to get. We will take a small step today, move the needle forward, and continually push for more in the years to come." Well, this is a lot to digest. I hope you found it interesting to watch or listen to. I hope you learned something. More important than anything, I hope you got something educational out of this. If you support what we're doing, please consider our membership program. For as little as $2 a month, you can put your financial faith behind our work over at 10thamendmentcenter.com/members. If you don't have any loot, don't worry about it. We'll continue doing this for free as long as we can, but we can reach more people every time you pitch in and help out. And we try to make it as cost effective as possible. But if you don't feel any pressure. There are a number of free things that you can do to help us spread the word. Reviews on Apple Podcasts or any other podcast platform help a ton. So does smashing a like, leaving comments, especially in the archive, posting links to episodes, whether it's YouTube, Facebook, or some other mainstream platform. Subscriptions, notifications, all that stuff triggers the algorithm primarily of the mainstream platforms, and it tells those platforms to show the program to more people. Again, I'm going to check the chat a little bit later today. I know I'm running really long on this episode today, but I hope you really enjoyed this. I hope you had a great weekend. I appreciate you being here, and I'll see you next time here on the Path to Liberty.